to say what you're saying is inconsistent with what I saw on his own camera.
She basically ignored you the entire evening.
That's not how I interpret it, no.
I didn't ask you how you interpreted it. I asked you what she did.
Courtrooms are where the egos of some of the most corrupt cops come crashing down. Today, we'll explore the most satisfying moments when these officers were exposed and taken down in court, just like the cop who ended the life of George Floyd.
You were the officer who approached the passenger side of the vehicle. You approached George Floyd on May 6th of 2019, is that right?
That's correct, yes.
And you had your gun drawn when you approached Mr. Floyd, isn't that right?
Yes, I pulled it, yes.
And when you approached Mr. Floyd, he said, "Don't shoot me, man, I don't want to get shot," right?
Something like that, yes.
You told him to undo his seatbelt, correct?
That's correct, yes, ma'am.
And he did that, right?
Yes, he did.
And then you said, "Put your hands where I can see them," correct?
Yes.
And then he put his hands in the air?
Yes.
And then you told him to put his hands on the dash, is that right?
That's correct.
And that was when you grabbed his hand and forcibly put it on the dashboard of the vehicle, correct?
Fallen, yes.
And then the other officer with you on the other side of the vehicle changed that to put your hands on your head, correct?
That's correct.
They did all that and didn't investigate anything. Humanity and basic human decency were not in these cops' dictionaries.
Was he awake during this incident?
Yes.
He was conscious?
Yes.
He didn't appear to be in medical distress to you when you were pulling him out of the car, is that right? He was talking to you, he was standing up, is that right?
I don't know if it was specifically, sometimes he was talking, sometimes he was mumbling. He was incoherent in my mind a lot of the time during there.
But you got him out of the car and you handcuffed him, right?
That's correct, ma'am.
And he stood next to the car, right?
Yes, ma'am.
He asked you not to beat him up, correct?
That's correct, yes.
He was able to walk, right?
Yes, he was.
She's asking these questions to make it clear that Floyd wasn't drunk, sick, or had medical issues. While he was talking to them meant that he was sane and posed no threat.
While you were interacting with Mr. Floyd, he didn't collapse on the ground, correct?
No, he did not.
Well, the answer is stricken. The objection is sustained.
You were asked some questions about what the other officers were doing, correct?
That's correct.
Your attention was focused on Mr. Floyd, correct?
Yes, it was.
And Mr. Floyd didn't drop dead while you were interacting with him, correct?
No.
Thank you. Nothing further.
Basically, two officers at the scene gave two different commands to Floyd, hands on the dash and hands on the head. He can only do one, so they used this trap to drag him out. Eventually, this cop was sentenced to 21 years in prison. This officer certainly earned his karma, but things took a bizarre turn when this next cop's qualified immunity was revoked.
He had nothing in his hands, and he was shot twice and killed.
A routine traffic stop in 2011 ended tragically when Officer Osvaldo Villareal fatally shot Benny Herrera, an innocent man. Years later, Herrera's family sued the officer, and this video documents a pre-trial hearing related to that lawsuit.
This is a tragic case, there's no question about that. But Officer Villareal was required to make a split-second life and death decision.
What required him to do that? It doesn't look to me as though he was the initiator.
The fact that Mr. Herrera, first of all, he had been acting erratically before the shots were fired. He moved from a place of relative safety on the shoulder of the road into the roadway. He was skipping.
But if we're talking about Officer Villareal, how much did he know about the prior behavior?
He saw all of that.
I have to say what you're saying is inconsistent with what I saw on his own camera. That is to say, the point at which he began to get close enough to see anything. Some of that earlier stuff was on the other camera, but not on his.
Shooting man in seconds? Cops these days really don't have the guts to investigate. They are so scared out of their minds, everything seems like a threat.
His camera was turned on, but
His
he
camera
testified.
his camera was turned on well before he got to the scene.
He testified in deposition that he saw Mr. Herrera on the side of the road, and then he saw.
Well, he can testify to what he wants to testify to, but I want to tell you what I saw on his own camera tells me that the early part of this he did not see, could not see. That was his intention, you say?
That was his intention, and that's in his deposition.
Again, I'm relying on what's on the videotape, and now this is in Officer Villareal's car. I hear him say, take your hand out of your pocket, and I hear the gunshot almost simultaneously.
Exactly.
They cannot be separated by more than a second.
And that's exactly the time period when Officer Villareal had to make his decision.
And to top it all off, his PD cleared him of any wrongdoings. The system does support corrupt pigs, or else this one should have been fired that exact day.
Before, he was asked in deposition, well, what were you going to do when you asked him to take his hand out of his pocket? Well, I was going to put him in a control position. That's what he intended to do.
So he's taking his hand out of his pocket.
Yes.
And as he's obeying the officer's command, he gets shot.
But it's the way that he does it, Your Honor. He didn't just stand still and take his hand calmly out of his pocket. Is he doing this peacefully? Or does he have something in his hand that could be a threat to me and is my life in danger?
Well, right.
He had a fraction of a second to make that
don't we
decision.
have to view this in the light most favorable to the plaintiff here? I mean, and so if we do what you just said right now, offer two possibilities.
The body cam footage made it very obvious that the officer was in the wrong, and the judges also felt that his qualified immunity needs to go.
Here, Mr. Herrera was arguably complying with Officer Villareal's order to remove his hand from his pocket at the time that he was shot. How is it that we determine that we should grant qualified immunity?
Because qualified immunity allows for police officers to make mistakes. It allows for the possibility that officers will make mistakes in judgment, and that's exactly what happened here. Officer Villareal had a choice to make. Do I wait and see whether there's something in the hand that could kill me, or do I shoot? And he made the decision to fire. We know with the benefit of hindsight, obviously, that was wrong.
Villareal got off easy, basically. No real reason for the shooting, but he's still on the force. Go figure.
It seems like he had a better vantage point possibly than Mr. Villareal.
He actually didn't, for these reasons. Officer Miali was facing, from his point of view, he saw Mr. Herrera's back, not Mr. Herrera's front. So he couldn't see, and he testified in his deposition that he couldn't see Mr. Herrera's hands as they were coming out of his pocket. He also, if he had fired, he would have fired toward an apartment complex. Officer Villareal fired toward a block wall.
I guess the issue I'm having here is that these are arguments, in my mind, for a jury. That certainly you can lay these out, but we're at a very limited scope here. This is not jury redo. We have to determine based on the fact as alleged by the plaintiff. And
Right.
they're gonna say, no, it was, he simply had his hand in his pocket and these officers were coming up on him really strong. They created the tension, they rose the adrenaline, not him. You have to lay out, take their facts, not the facts as you want. You gotta stick with their facts and explain why under their facts, you win as a matter of law.
I agree, Your Honor.
But this tyranny wouldn't last long because the expectations of the victim's family were high.
As long as the historic facts are undisputed, the question of whether or not Officer Villareal's actions were reasonable is a question of law. It's not a question that you give to a jury, because we don't want juries second-guessing the very, very difficult life and death decisions that officers have to make.
I agree, but at this stage, again, this is not an argument to a jury. For us to even have jurisdiction over this case, if we take those facts, you're saying that as a matter of law, Officer the shooting here was legal.
Yes,
Those
it was objectively reasonable. Well, not just those facts. Officer Villareal knew that Mr. Herrera was a suspect in a domestic violence incident.
Okay.
He knew that he had a gang affiliation, that he was on parole, that he had a warrant out for his arrest. All of those things factor into
on parole. I don't remember on parole. They said
on parole, yes, and there was a warrant out for his arrest.
What do we know about what Officer Villareal knew with respect to whether he was armed?
We know that dispatch told Officer Villareal and Officer Miali that Mr. Herrera was not known to be armed. But that's not the same thing as saying he wasn't armed.
The judges argued that the officer should at least be tried, as the other party had substantial evidence to challenge his qualified immunity.
Espinosa, the suspect, had refused to put up his hands, had threatened the officers, and an officer believed that she saw something in the suspect's hand, saw him move his arm, and was worried he was going to shoot her. But yet we affirmed the denial of qualified immunity in part because the suspect had not brandished a weapon or spoken of a weapon.
The defense tried everything, but the judges weren't having it. At least he didn't plead insanity like all the other cops do.
Here, the domestic violence incident was over.
Yes, and there.
So, I mean, how does that strengthen your case? I mean, that was, if you're arguing that it was an ongoing domestic violence, so.
Fully on what he knew at the time. And it's easy for us to sit in hindsight and say, well, Mr. Herrera didn't have a gun. Mr. Herrera didn't really pose any
I don't think
threat.
anyone here said that one time.
No,
I think what we're focusing on, again, the narrow standard we have to deal with here, and that's what we're dealing with. This is not a jury trial. This is not summary judgment. It's a very limited thing. No one here has raised about the fact he didn't have a gun.
I understand. The trial court did.
And both officers said it looked like he had something heavy in his pocket.
Okay.
All right. And then just before Mr. Villareal opened fire, Mr. Herrera rapidly removed his hand and moved quickly, it seemed like, toward the officer's car. Why isn't that enough?
Well, because sticking on the undisputed facts, the officers had no information that any weapon was involved in a crime. They were specifically told he was not known to carry weapons.
The cop had no need to escalate the situation. He could have just taken a chill pill and relaxed himself and the people he was supposed to investigate.
Opposing counsel that he's entitled to make a reasonable mistake.
Well, if that was the standard alone, then every single shooting case, the defense would argue that an officer is entitled to a reasonable mistake, and that's the end of the analysis. I think for purposes here, one has to look at the facts supporting the plaintiff's version and then decide whether one can say as a matter of law that the shooting is justified. Both hands were visible, and he had nothing in his hands, and he was shot twice and killed. We specifically asked the officers about their training, and they conceded, which is included in the cites in our brief, that deadly force is a last resort, only to be used in the direst of circumstances, only when no other reasonable measures are available.
No matter what the defense argued, the facts were clear. Herrera was dead, and Officer Villareal was responsible for his death.
The jury does not get to decide qualified immunity?
Qualified immunity is a question of law for the court.
You mean, so depending on, the jury has to decide whether or not there's been a constitutional violation, and at trial the jury cannot say to your officer, you're off the hook because you have qualified immunity? That can't be right.
The jury has to decide the underlying predicate facts.
I understand that, but I think I'm arguing on your point. If we send this back, I don't think you want to say qualified immunity is no longer available to you at trial.
Absolutely not.
Well, I think that's what you just said. That's why I'm speaking up.
That was not my intention at all.
If everything goes bad for your client, that is to say, if we send it back, if the jury says no qualified immunity, and if the jury comes in with an award of some amount of damages, will your client pay those damages out of his own pocket, or will it be paid by his employer?
It should be 99.9% of the times it's paid by the employer. I don't see why it would be different.
Well, by statute, California statute says it's paid by the employer unless they're punitives.
Yes,
isn't that right?
That was what I was going to say.
So that doesn't say 99%, it says 100.
Well, I was going to say, unless there were
punitives.
If there were punitive damages, the city would have the option of deciding whether to pay those punitives. My understanding is that
at that point, I got the answer. Got it right.
Finally, some justice for Herrera. Officer Villareal's qualified immunity was revoked and a trial took place. The court ruled that he had used unlawful deadly force. The city also paid Herrera's family $1.4 million in compensation as the case proceeded to trial. This next sorry cop was also being questioned for excessive force.
Did you apprehend good guys?
Detective for him.
Never. I take that back. I bit a victim one time because she jumped in front of me.
Do these cops not have any trigger discipline? Daytona Beach PD officer Joshua Mercereau was in a gunfight with Marvin Jones. Jones got hit 5 times, and his girlfriend, Aviana Bailey, got caught in the crossfire. She's paralyzed from the chest down now, so she's suing.
Playing, fumbling, doing something with in his lap. There's none of this. There's none of this. It's this. And he's looking at me the whole time. And then it happens.
What happens?
He sticks the gun out the window and points it at me.
Okay. How does he stick the gun out the window?
If I'm sitting in the driver's seat, where would my So he just went just like that.
Okay.
And it was between the mirror and the A-post.
Okay.
Well, actually, if I'm driving,
Exactly.
I'm sorry. If I'm driving, the driver's side is the door is here. So he did this.
Okay. Because you had him moving.
Excuse me.
Further into the passenger compartment.
No, that was
to the
completely.
right.
That was my mix-up in the side. It was the right side that he did it with, and then he put the gun between the window.
Officer Joshua couldn't even get the story straight. All of his memory issues are going to pop up right now.
You said right side again.
Left side. I'm dyslexic.
Are you dyslexic?
No,
Okay.
I'm sorry. I didn't. That was a bad joke.
Do you recall how many rounds?
Just one at that time.
Okay. And where did it strike?
The hood and windshield area, right in front of him.
And how many muzzle flashes did you see in total at scene 2?
At least the initial, at least one, and possibly two. I can't count them. I can't tell you how many exactly I saw.
The man shot a guy 5 times and sat there like he was at a coffee date with his friend. He showed 0 signs of remorse.
I was committed to engaging him, and I did that. At which point, my ankle rolled off the curb, and I fell on my back.
Okay.
I was falling and still shooting, so somehow the gun jammed from limp wristing it.
Okay. Fired at you, or you saw several muzzle flashes?
Yes.
Okay. How do you define several?
Objective form.
1 or 2? 2 probably.
Okay. Several's not one.
Yeah.
We agree to that. Do you mean is several more than 2?
Objective form.
I would say 2.
Okay.
So we'll say a couple.
Okay.
Investigators pressed Joshua about the tragic incident, but he continued to make light of the serious situation, attempting to joke instead of addressing it responsibly.
In your deposition, you discussed dust. Tell me about that.
Form.
Was there dust at scene 2?
Yes.
Tell me about that.
Form.
There was dust at scene 2.
And I understand there may have been dust on the ground, but did the dust become airborne?
Yes, from the suspect's vehicle spinning in the grass, which was dry.
Did the dust settle? That's what we say. Before you got out of your car?
No.
Okay, so there was still some dust in the air.
Correct.
When did the dust settle?
Objective form.
Still hasn't settled. I guess it never really did. I mean, that I remember.
Okay. Before you got out of your car and engaged Marvin Jones, did you know anything about him or his background?
Just the fact that he might have some felony warrants out of New Hampshire.
How did you learn that?
Apparently, somebody called from New Hampshire to rat him out.
Joshua had no remorse for his actions, and as the deposition continued, his answers were about to get even more weird.
What threat was posed to the safety of an officer or other person at the point you first got out of your car?
There was none.
Okay. What threat to an officer or other was posed when you first drew your firearm?
There was none.
What threat to an officer or other was posed when you got out of your car, when you took a step towards the Lincoln?
Objective form.
At this point, the defendant's actions.
Okay. Which were what?
Fumbling around on his, making very furtive movements.
The attorney then questioned Joshua about his troubled past, which included being removed from his role as a canine officer.
Did you have your duties as a canine handler revoked or rescinded at any point?
Yes, I did.
What happened or why?
Form of objection.
In my opinion,
Yes.
I was doing my job too well.
What does that mean?
It means I was beating the streets and I was catching bad guys.
Okay.
There wasn't a lot of bad guys that got away from me.
Because your dog got him?
Because we got them as a team.
Okay.
if you have an above average bite ratio, that means you could be using your dog too much.
Okay.
A bite ratio is how many people you apprehend and then how many people you dog bite during that apprehension. So they're saying 30%. So they're saying out of 10 people that you apprehend, you should bite 3 of them, let's say.
Okay.
Which never made any sense to me.
This cop was downright dirty and arrogant. These are exactly the kind of people you don't want on the force.
When was your canine handler duties taken away?
Late 2011. As a matter of fact, December 23rd, 2011.
Why does that date stick out?
Worst day of my life. I enjoyed the job. I would have paid the city to come do that job. Tracking down bad guys and finding them and apprehending them.
Did you apprehend good guys?
Never. I take that back. I bit a victim one time because she jumped in front of me. So I did. I bit a victim one time.
Was that another officer?
No, it was a victim, a domestic violence victim.
Joshua's history was riddled with poor decisions and excessive use of force. The attorney dug deeper, exposing his psychopathic nature.
Do you need supervisor authority to conduct a strip search?
Yes, sir.
Did you obtain supervisor authority before you searched Justin Riddle?
No, sir.
Did you receive counseling or did a supervisor talk to you about that and tell you did that portion incorrectly?
Yes, sir.
There was a newspaper article about a lawyer that claimed you used excessive force. Do you recall that incident?
Yes, sir.
Tell me about that.
He was, Roe. He was hammered. He was drunk.
Oh yeah, I remember this one. This is the one where you were alleged to have gone in a home without permission, like moved somebody's arm. You recall that incident? What happened there?
I was on K9. We were looking for, they're twins, but we saw one on the bed through the window. And I'm like, that's him. That's him. But this is before I knew he had a twin or a brother. So he had a felony warrant.
The twin did?
No.
The one of them
had a felony warrant.
The guilty one, not the innocent one.
So the mother's there, and we got the place surrounded, and basically she said, you're not coming in. Well, he's in there. We can see him in there. We can force entry on a felony warrant. I eat that one. That was my responsibility all day long for not knowing that it's the brother. They do look different. If I had seen his face, maybe pay attention to his haircut.
Did you ever arrest a good guy?
Did I ever arrest a good guy?
Yeah.
Not that I can recall.
This next case has a chief investigator who just wants the defendant to die.
You indicated that you reviewed several of the videos on his Ring app on his cell phone. Is that right?
Yes.
So you obviously had not only possession of his cell phone, you had possession of his login account information to get into the app on his cell phone. Is that right?
I don't believe we had the password. We had his email account associated with the Ring.
Which means
app.
some way or another, you could get access to the Ring videos.
Correct.
And watch those Ring videos on his app on the phone.
Yes.
Which means you had full access to the app. You could keep videos, you could save for later, you could delete videos, you could do anything you wanted to within that app, correct?
Yes, those are the capabilities within that app.
Trooper Proctor, did you delete any of the Ring videos ever from John O'Keefe's phone?
Absolutely not.
Did you delete a video of Miss Reed arriving to One Meadows at approximately 12:41 a.m. on January 29th, 2022?
Absolutely not.
You will agree, Trooper Proctor, that the video of Miss Reed returning home from 34 Fairview at approximately 12:41 a.m. is not there.
Correct.
As the case officer, you're aware that Trooper DeChico also reviewed some or all of those videos, correct?
Yes.
And he did that at your request.
Correct.
This is a very serious allegation by the attorney. Tampering with evidence is a serious crime, and in some cases, the prison sentence for it can be up to 20 years.
He took notes of his review of those videos, correct?
Yes.
And then he provided those notes to you so that you could then memorialize those notes and your notes in a broader report that you then drafted in November of 2022, correct?
From memory serves me, the report I wrote regarding the Ring camera was based off my observations of the videos that I had watched.
So basically, 2 different officers reviewed the Ring doorbell footage, and this other officer also left notes. At this point, Proctor was getting visibly anxious.
So when you reviewed his notes, did you see that they were on some sticky pads? You remember that?
That sounds about right.
Do you recall exactly, as you sit here, exactly what was on one or more of those sticky pads that you reviewed from Trooper DeChico?
I don't know.
You reviewed this previously before you wrote your report, correct?
Yes.
All right. And you note that at 0041, which is a time relative to what DeChico was looking at on the Ring video, he indicated taillights from driveway, parentheses, I think she arrived home, in parentheses, correct?
Correct.
0041 is what? What's that in reference to?
Just after midnight, the approximate time where Miss Reed will be returning from Fairview Road.
Sometime between when Trooper DeChico wrote his notes and when you wrote your report, that video footage vanished, correct?
There's also no date on Trooper DeChico's notes. We have many dates from Ring video, so I don't know if he's referencing a different date.
Well, you're aware that the video footage from 12:41 a.m. is gone, correct?
Yes, it's something I've tried to find through Ring for months, as well as the video when Miss Roberts, Miss McCabe, Miss Reed arrived back at John's and they're looking at the broken taillight. That video is gone as well.
So, at some point, while this footage was in Massachusetts State Police custody and being reviewed by Trooper DeChico, that video existed, didn't it?
Objection.
The objection is sustained. Mr. Jackson, don't waive that again, okay?
Yes, Shawn.
These videos magically vanished from O'Keefe's Ring doorbell app while his phone was in police custody, and Proctor has no explanation for it. Now we move on to this man's more sadistic side.
Did you develop some sort of hatred for Miss Reed?
Objection.
At any point in your investigation?
I'll allow it.
Again, we follow the facts and the evidence which showed Miss Reed hit Mr. O'Keefe with her vehicle. And yes, at times I got emotional because of that, and I said some stuff, texted some things I shouldn't have, but it was based off the evidence.
As a matter of fact, you did express your feelings about Miss Reed in yet another text message that we haven't gone over here today. Is that right? On February 4th, 2022? Might as well turn to tab 10.
Tab 10?
It's either the bait stamp or the...
This is your triple F, this is Foxtrot. You literally said that you hope that Karen Reed, the subject of your investigation, the woman sitting to my left, about 7 feet from me, that she would just die, correct?
The figure of speech.
You wanted her to, the figure of speech is you wanted her to kill herself.
No.
Right?
No, it's not.
Trooper Proctor, Karen Reed, in your investigation, had quickly become a very serious problem for you, hadn't she?
Objection.
Sustained.
Did you believe that Karen Reed was a problem or an issue for your investigation?
Objection.
I'll allow it.
No, absolutely not.
In your words, quote, all the powers that be want answers ASAP. That's what you texted on January 29th, right?
Yes.
That put a lot of pressure on you, didn't it, Trooper Proctor?
There's a lot of pressure in every case, sir.
This case involves a Boston cop whose family you were actually connected to, correct?
Loosely.
Chris L. Loosely.
Yes.
Julie Albert. Loosely.
Yes.
Colin Albert. Loosely.
Yes.
Kevin Albert. Loosely.
Yes.
Loose enough to leave his badge and his gun in your cruiser after a night of drinking, right?
Objection.
Sustained.
You agreed in your group chat that you needed to, quote, make this cut and dry because another cop was involved. Those are your words, right?
Objection.
Where is this?
This was referred to in earlier text messages, group chats this morning.
So is that right? Did you say that, sir?
I did text that. I don't know if it's in the exact context. But yes, those were my words.
Chat.
Yes, that was in the group chat.
He said all that about Karen Reed and then says that his report was unbiased? He literally wanted a woman out of the picture because his friends were getting involved. And this guy was allowed to be the lead investigator? No wonder people hate the police. And this lawyer was about to get even more aggressive.
You believed, Trooper Proctor, that your life would be much easier if Karen Reed was just dead, didn't you?
Objection.
I'll allow it.
No. Like I had said, it was a figure of speech. My emotions got the best of me based on, the fact that Miss Reed hit Mr. O'Keefe with her vehicle and left him to die on the side of the road. So my emotions got the best of me with that figure of speech.
Well, let's talk about your figures of speech. During the course of your investigation, your figures of speech include the following. She's a bitch.
Objection.
Is that right?
Yes.
A whack job, correct?
Yes.
A retard, right?
Yes.
Her balloon knot leaks, right?
Yes.
No ass, correct?
Yes.
She's fucked, according to you, right?
Yes.
Ass leaker. That was the word you used, a figure of speech, right?
Correct.
A girl who shits herself, right?
Correct.
And then fuck her, correct?
Correct.
Would you agree, Trooper Proctor, that you have dehumanized Karen Reed during the course of your investigation with comments and words like this?
Objection.
I'll give you this one, Mr. Jackson.
Would you agree with that?
I would say based off that language, yes.
And you admitted, in your own words, that the cop homeowner wasn't going to, quote, catch any shit, right?
Correct.
Shame on him. I think this case is very cut and dry. Trooper Proctor had an obvious bias, and his actions proved that his investigation was targeted. The end result of the trial is a case for another day. But another character that we also discussed before is worth mentioning, ATF agent Brian Higgins. His court proceeding was filled with drama because his relationship with Karen Reed was on display.
My question is, you seem to have a problem admitting that you had a romantic interest in my client. Is there a reason for that?
I was attracted to her.
Right. Physically attracted.
I thought she was an attractive woman.
Romantically attracted.
I'm not going to go there. No, I don't agree with that.
Of course you're not going to go there, because that would put you in a very awkward position, wouldn't it, sir?
Objection.
Not at all.
So the objection sustained is to the form. You can ask it differently, and that answer will be stricken now.
I'm sorry, Your Honor. May I?
Yes.
You were sexually attracted to her.
I was physically attracted to her, yes.
Attracted to her was my question.
Well, I think in the text I said, you're hot.
Okay. So my question again, Mr. Higgins, you seem to not want to answer my question. My question is, were you or were you not sexually attracted to my client?
Yes.
In an effort to try to prompt the conversation to continue, did you not?
I reached out to her, but I wouldn't say that's what it was about.
Well, you texted her stranger, didn't you? Not once, but twice.
I believe so.
Take a look, if you don't mind, at, this is a page from what you've just seen.
So he needs the...
I'm sorry. I was thinking that was right in front of you. May I approach?
Please.
Thank you. I have just a second.
Maybe that should just stay with Mr. Higgins.
Thank you. That's easy to find. It's literally the last page. Report permission, may I publish?
Yes.
Does that look like a fair representation of what you're looking at, the last page of that series of texts?
Yes.
At the very top, did you read what you write in the blue bubbles starting at the top?
Haha, stranger, stranger.
And then what was the response from Miss Reed?
Hey, I was at the Hilly all weekend.
And what did you respond at that point?
I have not heard from you.
And by the way, if you look at the next date down, what's the date underneath I have not heard from you?
The 23rd.
So this would have preceded the 23rd, correct?
Yes.
Okay. Then on the 23rd, and by the way, after you texted, I have not heard from you, she did not respond, correct?
She did not respond.
Then on the 23rd, she did respond with phone works, correct?
In the arrows, like both ways.
Right.
Yep.
And then what did you text after that?
I just said, thought you were all set.
And how did she respond?
She said, we're talking? No.
No, that's all I have for that.
Okay.
Bring the lights back up. So clearly with that last text, her response was, in response to you saying, thought we were all set, she said, with talking, no. Correct?
Yep. Yes.
Did that indicate to you that with flirting, yes, we're all done?
No, I didn't read anything into it.
Okay. But you did read where she said, with talking, no, correct?
Yes.
And then you responded, how?
I said, are you sure?
And did she respond?
No.
Now, you had discussed your flirtations, if I can use that word, that you had with Miss Reed with your friends, at least some of them, correct?
I don't recall that, no.
Do you recall that you openly shared the details of your interest in Miss Reed with your work supervisor at the DOJ?
Well, that was after I shared what happened, that she kissed me. Yes, I did share that with her.
And that was with...
that was the first time.
That was with a person by the name of Kate Dowd, is that right?
That's correct.
And that was before January 29th?
Yes.
And that's because your interest in Karen Reed, whether you call it romantic or sexual or whatever, your interest was something that was at least occupying your mind at that point, correct?
No.
It was occupying your mind enough to share it with your boss.
No, what I shared with my boss was the fact that she kissed me. That was it.
The overall story that Reed's attorney argued is that Reed did not in fact hit her boyfriend and offed him. Someone present at Brian Albert's party might have done that, and then tried to pin the case on her, as we saw how the lead investigator was doing. The main culprit who might have the most probable motive is Brian Higgins.
Did you discuss your flirtatious relationship with Karen Reed with Brian Albert at any point?
No.
Never?
No.
So you were on a 4-hour drive in a snowstorm back from New York with Mr. Albert, and your interest in Karen Reed never came up?
No.
Even though he's a good friend?
Yes, just something I wouldn't talk about.
But had several drinks before you even got to the waterfall, right?
I think it was 3 to 4.
Did you drink additionally at the waterfall?
I did, yes.
Did you drink whiskey or beer or what?
Whiskey.
Okay. How many do you think you had?
I couldn't put a number on it. At least a couple.
And ultimately you left from there in your personal vehicle and drove over to, that's the Jeep, over to the waterfall, correct?
I drove over to the waterfall?
I'm sorry.
I was at the waterfall.
Left the waterfall, drove over to 34 Fairview.
I did, yes.
When John walked in to the waterfall, were you already there?
Yes.
He greeted you, you indicated, correct?
Yes, I believe so.
Karen walked in with him?
Yes.
But she did not greet you, did she?
I think they kind of went like that in different directions.
Right.
Yes.
Did she greet you?
No.
Right. So she walked over toward the corner of the bar, and John came over and greeted you, and then walked over and joined her, correct?
Yes.
Karen didn't stop what she was doing once she was over in the corner of the bar and come over and say hi to you?
I didn't have any interaction with her that night, no.
So safe to say that throughout that evening, once she was sidled up next to John O'Keefe or friends that she was with, she never turned back around and came over and even acknowledged you, correct?
That's correct.
So she basically ignored you the entire evening?
That's not how I interpret it, no.
I didn't ask you how you interpreted it. I asked you what she did. Did she ignore you or did she pay attention to you?
Objection.
You can go ahead and answer that. Did she ignore you?
No.
So she paid attention to you? Came over and said hello, shook your hand, gave you a hug?
Well, just because somebody didn't come over doesn't mean they ignored you.
Did she do those three things?
Hug, what was the other thing?
Say hello, shake your hand, give you a hug?
No, she did not.
No, she didn't do any of those things, did she?
No.
It's like you didn't even exist.
I think that's dramatic. No, I don't look at it that way.
Did she ignore you or not?
No, she did not ignore me.
So what did she do to not ignore you?
She was
What's her interaction with you?
Can I answer now?
Sure.
In my opinion, she was working the room, talking to people, saying hello, catching up.
Right. The one person she didn't come over to talk to and say hello to and catch up with is you.
Well, I don't know that I was the only person, but I was one of the people that she didn't say hello to, yes.
Treated you sort of like a stranger.
I don't feel that way, no.
She actually positioned herself away from you at the other end of the table on the opposite side in the corner. Isn't that right?
I don't know where she was all night, no. I don't know.
Did that upset you that she ignored you or didn't pay attention to you?
I did not feel ignored and didn't upset me at all.
But it bothered you enough to send her a text, didn't it?
No, it was a flirtatious text. It was just, that was it.
It bothered you enough to send her a text that said, with 6 M's behind it.
Okay.
And, well, correct?
Well, it wasn't like that. It was, well, that's it.
Ignoring the fact that Higgins just confessed to drunk driving, Reed did ignore him while she was with her boyfriend, so much so that he had to send desperate text messages to her. Would that have made Higgins angry enough to harm the only man standing between him and Reed?
When you testified at the prior hearing, you were asked, so you saw someone else come? Question. Answer, somebody else. Yes, end quote. That's what you testified to under oath, wasn't it? You saw someone else come? Answer, somebody else. Yes, correct?
Yes, but I also said that I wasn't paying
Mr.
attention.
Higgins, I realize that you want to explain your answer. I've asked you a very simple question. Was that your testimony in front of another proceeding?
Yes, it was.
At another proceeding, which you were under oath?
Yes, it was.
Okay. You also said that you only remember seeing that person come in briefly. And it looked like he was having a conversation with the two girls. Briefly, correct?
Yes.
You were asked how long was the person in there roughly, and you said it was quick. Less than a couple of minutes. I mean, it was quick, correct?
Yes.
And then you were asked what he looked like, and you said, I feel like they were a little bit taller. They had dark hair, correct?
Yes.
So you testified that a tall, dark-haired male came into the house, at least briefly, in your testimony, correct?
Yes.
Approximately when in the timeline of events did that unidentified male enter the residence?
I don't know the time frame. It would have been while I was there.
When you gave your statement to the Massachusetts State Police, you didn't tell them about a tall, dark-haired male coming into the residence at 34 Fairview, did you, on February 3rd?
I don't recall.
You were specifically asked by ADA Lally when you testified before the state court grand jury on April 28th, 2022, who else was present, correct?
Yes.
And you never mentioned a tall, dark-haired male coming into the house, did you?
No.
However, on June 1st, 2023, at this other proceeding, you were specifically instructed at the start of your testimony that it was a crime to give materially false statements in that proceeding, correct?
Yes.
And that's the proceeding in which you admitted that there was a tall, dark-haired male who came in the house. Yes or no? Yes or no? It was that proceeding.
Can you answer that, yes or no?
No, I can't, Your Honor.
Next question, Mr. Jackson.
Loverboy over here lied in front of the court. This is a crime because you take an oath before the proceedings. This lawyer was fully exposing Higgins on multiple fronts. Higgins' testimony is filled with embarrassing moments for the ATF agent. He really is a pathological liar.
You were speaking to Brian Albert in the middle of the night, approximately 3 hours before Mr. O'Keefe's body was found in his yard, correct?
No, that's not correct.
And that was 5 minutes before 2:27 a.m. when there was a Google search for how long to die in the cold, correct?
Objection.
Sustained.
Then, of course, you lied about that under oath in that prior proceeding by saying, I don't remember this phone call.
Objection.
Sustained.
Did you, in fact, tell the truth at the prior proceeding when you said, I don't remember that phone call?
I always tell the truth.
No cop got told off as badly as this next one. This African-American judge was no joke.
It's up to the court. I can get arrested? Yes, it's up to the court.
Mr. Dent was struck, kicked, and tased while on the ground by what appeared to be a group of angry, anxious police officers.
There's no better feeling to see some justice being served in the court, and what's even better is when it's being served to corrupt police officers. The second case saw the officer's life flash before his eyes when he realized what a mistake he made. But before we get to that, the atmosphere in this courtroom took a serious turn when the judge started to narrate what happened to the victim. On January 28, 2015, ex-cop William Melendez's traffic stop of Floyd Dent escalated dramatically. Court proceedings later revealed shocking details of the incident.
January 28, 2015, where his life changed forever. He was stopped by the defendant, a then Inkster police officer, and his partner, Officer Zeleniewski. Mr. Dent was stopped for a minor traffic offense and ordered out of his vehicle. With his hands extended out of his driver's window, he was grabbed out, thrown to the ground, and struck 16 times in the head. In his attempt to arrest him, he was thrown onto a window shield of a patrol car, bleeding profusely from a head injury. The responding police officers arrived as the defendant is wrestling the defendant to the ground. Mr. Dent was struck, kicked, and tased while on the ground by what appeared to be a group of angry, anxious police officers that celebrated after the defendant was beaten.
As the judge recounted the events, the officers' actions became increasingly disturbing. The aftermath of their conduct was particularly appalling.
The video in the car shows the police officers fist bumping as a celebratory act of bravery by the defendant and his cohorts. But the one image that struck out to the court was looking at Mr. Dent in his cell, shaking his head. In disbelief of what had occurred to him. What crime did I commit? Being a black man in a Cadillac, stopped for a minor traffic offense by a group of racist police officers looking to do a nigger. As police officer John Zeleniewski, auxiliary police officer, testified in court too, in his response to a text, was quoted as saying, "At least give me the satisfaction of knowing that you're out there beating up right now. LOL."
What makes the situation bad is that the officers had no shame in what they did. They were actually enjoying their gruesome acts openly.
How does this happen? On January 28, 2015, you did not fulfill your job. You performed Just Us, a game that began with a police stop. The purpose of it was to harass and degrade a motorist in Inkster, the man chosen for your game. Let's follow a car in a known drug area, and based on your years of training experience, you knew that the motorist would likely be a black person, no license, armed with a gun or drugs in a vehicle. Upon stopping Mr. Dent, you knew, and upon stopping Mr. Dent, who was dead wrong for driving with no license or license suspended, running stop signs, and weaving in and out of the back street, which the court saw on the video. Upon being stopped, Mr. Dent put his hands out of the driver's window in plain view. Your partner and you pulled him out. When he didn't move fast enough for you, you refer to it as resisting. I call it bowing down to your command. You utilized your dirty, hairy tactics and used excessive force to arrest him. Your job was twofold. Investigate the situation, be a positive example to Officer Zelenowski, kicking and tasing and ultimately throwing Mr. Dent into a windshield of a police car with a dash cam, which I refer to as the eye of justice. You were so into your bravado that you forgot the eye of justice was watching you and recording this disgusting beating, seeing Mr. Dent slammed into the window shield with blood running down his face.
This was also a hate crime because of the text messages exchanged. Racism is still pretty much alive in our police system to this day.
Fist busting after taking him down as a sign of bravery was just another cowardly act caught by the eye of justice. You knew better. You were better trained than any of those officers out there. You were more experienced. It took me several days to read the letters that people sent talking about your character, about the man that you are. 3 of those letters, I believe, were from African Americans, and one even professed to be like a mother. One or two things, either they're all racist or there's something redeeming about you that somehow in some way you forgot that night. The way you denigrated that man was awful. Who would know and who would care about a lone black man being assaulted by upstanding police officers? Boy, were you wrong.
We need more judges like her in our country today. She fearlessly stated the obvious and courageously addressed all the issues that everyone else was avoiding.
The other eye of justice captured you and your posse making fun of Mr. Dent, mimicking him struggling while you all wiped the blood off your uniforms with disinfectant while he watched. Such an awesome, caring, properly trained police officer. You led your fellow officers down a path of cowardly behavior. But today you will pay for it. There's an old saying, it ain't no fun when the rabbit's got the gun. It's equally applicable when he has the video. The eye of justice in this case. You betrayed your city. You caused your lovely wife heartache. And you caused Mr. Dent severe anguish. And finally, in the words of Vicki Yost, your commander, accountability is required to ensure continued community trust and healing.
Following a long verbal lashing, the judge ultimately handed down a punishment to Melendez, and his response is truly worth watching.
Only you and God can change your character. I've had an opportunity to listen to both sides. And I had to say this because I didn't say this during the trial. But it was my privilege to be able to oversee this trial because I had great lawyers. And great lawyers make jobs real easy. I am going to commit you to the Michigan Department of Corrections. However, after weighing the allegations in this particular matter and looking at all the circumstances, including what you've done and who the person I really believe that you are, I'm going to commit you to the Michigan Department of Corrections as to count 1 for no less than 13 months, no more than 10 years. As to count 2, I'm going to give you 90 days credit for time served and close it out. The court's going to give you 85 days for credit. You have 42 days to appeal my decision. That concludes this matter. Thank you.
Although some might argue that the punishment was not enough, it's still a win that the officer had to serve time and that he won't be on the force afterwards. Next up, we have the court hearing of Shawn Paul Reyes versus the state of Connecticut. Shawn sued the officers after he was taunted out of a public building.
Reyes circled around me and did not give me his name or accept the department card. As he headed up the stairwell, I thought in the best of City Hall, I keep him around and prevent him from going upstairs. He kept coming toe-to-toe with me. I extended my arms to prevent him from going to the second floor. Okay.
This is what it is.
If you want to, yeah. All right, do me a favor, we're not done yet. Sit. What's the pen? You got your pen?
Yeah.
Okay. I'm going to submit a warrant. I'm going to review the camera footage, right?
Yeah.
I'm going to get his statement. I got his statement, your statement, and the camera footage.
Yeah.
I'm going to put that all in a report.
Yeah.
I'm going to review it.
Yeah.
If I have probable cause to believe that your actions rose to the level of, I would call it an assault, since luckily he admitted to me that he was not injured and he did not want medical attention.
Yeah.
Although an impairment of, injury, according to definition, is impairment of physical condition. So I'm not going to do it to you.
Yeah, but I mean, I didn't.
But if I know it
hands,
doesn't matter. If you push somebody, I'm not going to do it to you because I don't want to assault you. But if you impaired somebody's physical condition,
like that. I just kind of put my hands up.
Well, okay. So, however, if I think it rose to the level of a discon, I'll submit warrants, maybe even for both of you. If some of his language is to the point where it's disruptive, then I'll submit a warrant for both of you, and we'll see and then it's up to the court.
So you I could get arrested?
Yes, it's up to the court. You got physical with somebody that, for the most part, you really had no reason to be physical with.
I didn't want him going.
Because he was filming.
Upstairs.
I know, but for what? For what? He's filming. What is he doing? Why can't he go upstairs? It's a public building. It's City Hall, for Christ's sake.
Like I said, if I was given those forms,
you know.
Shawn doesn't use any disruptive language and remains respectful. I'm sure you've seen us review multiple videos of his audits. The real deal is how physical the officer got.
After I had watched the library incident, I had seen on his channel that nearly every single one of those videos cast the police in a negative light. So I was fearful that regardless of what I did that day, right or wrong, the same would be done to me, as is exactly what happened.
Right. That didn't happen to you, right?
Oh, no, it did.
It did?
Yep.
Okay. And the incident at the library that you're talking about, the videos, you're talking about the videos involving, I think it's Tippett's and Utter, and the statement that if he'd done something 20 years ago, he would have been dead in the back of someone's trunk.
Objection is what?
20 years ago, that
He'll be dead. His teeth would be missing. I'd have removed his teeth. He would be dead.
This is not going to end well with you, you know that.
Okay, we'll see.
So the cop was worried that Shawn's video would cast him in a bad light by referring to a library video where a cop gave him death threats.
Relevance, hearsay, outside the scope of duress.
Sustain. Keep going.
Okay. The incident at the library, were you familiar with what happened there?
Objection, same, all three grounds.
Keep her out of that, Judge.
There's been some discussion in the trial thus far about the incident and how to message question.
And that involved Danbury Police Department, police officers, right?
The incident, I'm sorry.
At the library, sir.
Yes, it did.
And you're familiar with the library incident, right?
Yes.
And are you familiar that Mr. Reyes made a complaint about Danbury police officers in that case?
Objection, relevance.
I want to allow it as...
At the time of this...
Okay, here's how it's going to work. He's going to ask a question. Okay. He may object. I rule the objection. You don't answer until I rule the objection. Got it. It's just going to be user friendly. And that's partially me because I fall. So let's try that again. Ask the question again, answer and see.
These two incidents had totally different levels of intensity. The defense, in this case the state, was trying their best not to have the other Danbury officers be included in this hearing, because their statements were beyond inhumane. But the judge was annoyed by their interruptions.
At what point?
At any point.
I received a couple on my work voicemail, but I just didn't.
Did you put that in the police report somewhere?
Well, I was threatened after the fact.
Well, threats are important, aren't they?
It depends if you feel threatened or not, and I didn't feel threatened by them, I just deleted them. They were on my work voicemail.
So you didn't feel threatened about what people had said, correct?
Objection, pass to the next one.
I'll allow him to answer his question. Objection overruled.
It's a tough thing. I can threaten you right now. It all depends how you feel about it. I would hope that, you wouldn't feel threatened by me, but so at the time, I just deleted those messages. I don't remember if I felt threatened or not, but I didn't want to, I just deleted it. It was only a couple. It wasn't like the other people other officers.
This cop was just bluffing. Threats are no joke, and those threats could have been substantial evidence against Shawn in this case, but they weren't real to begin with.
Approach. Off the record. Approach.
Mr. Reyes arrested, is that what you did?
I would object because that mischaracterizes the testimony. He said he had a question in the morning, not the afternoon.
Sustained. It does mischaracterize the testimony. Ask a question, please.
Sir.
Everything Shawn's lawyers said raised an objection. Were all of his actions irrelevant? The defense didn't have any points of their own, so it seemed like they only wanted to disrupt Shawn's attorney. The judge was getting furious.
You weren't present in the clerk's office the afternoon of July 15th, 2021, correct?
Objection, ask the answer.
Sustained. We've had that.
Did the warrant that you did for Mr. Reyes pertain to conduct that occurred on July 15th, 2021 in the town clerk's office in the afternoon, sir? Yes or no, if you can?
Objection.
No.
That's the answer.
Okay. We're taking a recess. Counsel in chambers now.
All rise. Court's now in recess.
The judge was furious. He ordered both the lawyers into his chambers, and we can faintly hear how his mood was. The state's attorney's objections were so annoying that the judge had to personally give him an earful. The fact that the judge hasn't put a stop to this waste of taxpayer money speaks volumes about the level of corruption we're looking at here. And that's all for today. If you'd like to see more court hearings of officers being grilled, let me know in the comments below. If you liked the video, subscribe so you don't miss out on the next one. And make sure to check out this one too.
You decided on the 29th of January, 17 hours into this investigation, you decided individually, Trooper Proctor, you're not only going to put it on the girl, you decided you're going to make sure this is cut and dried, and the way you're going to do it is to make sure that she's